Okay, this is Domestic Relations Law, Article 3, 15A. Marriages of minors under 17 years old. Any marriage in which either party is under the age of 17 is hereby prohibited. Any town or city clerk who shall knowingly issue a marriage license to any person, one or both, of whom shall be at the time of their contemplated marriage actually under the age of 17 years, shall be guilty of a misdemeanor, and on conviction thereon shall be fined in the sum of $100. So, marriage cannot get married under the age of 17, and if the if the town or the city clerk who issues the marriage license tries to, they'll be convicted and found guilty of a misdemeanor upon conviction and shall be fined $100. So 15A of the Domestic Relations Law, cannot get married under 17. If they do, misdemeanor, $100. Okay, this is Domestic Relations Law Article 10, which is about actions for divorce. I'm guessing this is all contested stuff, obviously. Okay, so the grounds for divorce, and I'm just going through the basics. Okay. 1. Cruel and inhumane treatment. 2. Abandoned for 1 or more years. 3. Defendant in jail for 3 or more years. 4. Adultery. 5. Judgment of separation for 1 or more years. 6. Agreement or separation filed in the clerk of county either party resides, or a memorandum in lieu may be filed, and that's for 1 year. For a period of 1 or more years. Such agreement shall be filed in the office of the clerk of the county wherein either party resides, and may file a memorandum. I said that. 7. Broken down irretrievably for at least 6 months. That's the only one that's not 1 year. So if you have a judgment of separation or an agreement of separation, you have to be separated, or the judgment has to be in effect for 1 year. If you have if the relationship between husband and wife has broken down irretrievably for a period of at least 6 months, provided that one party has so stated under oath, that is 6 months. No judgment of divorce shall be granted unless support and property visitation have all been settled. 170-A, Domestic Relations Law, Article 10. Special action. A spouse against whom a decree of divorce has been obtained under the provision of subdivision 5 or 6 of section 170 of this chapter, where the decree, judgment, or agreement of separation was obtained or entered into prior to January 21st, 1970, may institute an action in which there shall be recoverable, in addition to any rights under this or any other provision of law, an amount equivalent to the value of the economic and property rights of which the spouse was deprived by virtue of such decree, except where the grounds for the separation of judgment would have excluded recovery of economic and property rights. B. In determining the value of the economic and property rights, the plaintiff's interest shall be calculated as though the defendant died intestate, and as if the death of the defendant had immediately antedated the divorce. C. The defendant shall establish that intervening circumstances have rendered an award described. The court may award the plaintiff such portion of such economic and property rights as justice may require. D. If the defendant shall establish that the plaintiff has expressly or implied waived all or some portion of the aforesaid economic or property rights, the court shall deny recovery of all such rights, or deny recovery of the portion of such rights as justice may require. E. Actions under this subdivision may be brought within 2 years of the enactment of the section, or within 2 years of the obtainment of the subject divorce, whichever is later. Okay. Section 171. When a divorce is denied, although adultery was proved. In either of the following cases, the plaintiff is not entitled to a divorce, although the adultery is established, which is one of the grounds for divorce. 1, where the offense was committed by the procurement or with the connivance of the plaintiff. I don't know what that... Does that mean like they went to Thailand and the wife was like, oh, hey, get a girl and I'll pay for it and you can like have sex with her, and then come back and be like, oh, he committed adultery? I don't know what that means. 2, where the offense charged has been forgiven by the plaintiff. Oh, so I guess if he cheats on you and you forgive him, then that's not a reason why. That's ridiculous. The forgiveness may be proven either affirmatively or by the voluntary combination of the parties with the knowledge of the fact. 3, where there has been no express forgiveness and no voluntary cohabitation of the parties, but the action was not commenced within 5 years after the discovery by the plaintiff of the offense charged. So I guess if there is adultery, it has to be commenced within 5 years after. Okay. 4, when the plaintiff has, let's go back. It has to be commenced within 5 years after you found out that he cheated on you, I'm guessing. 4, where the plaintiff has also been guilty of adultery under such circumstances that the defendant would have been entitled, if innocent, to a divorce. What? Oh, okay, so if you both cheat on each other, then it doesn't count. Okay. 172. Co-respondent as party. In an action brought to obtain a divorce on the ground of adultery, the plaintiff or defendant may serve a copy of its pleading on a co-respondent named therein. I'm guessing this is like the girlfriend, or whatever, the gumata, whatever the fuck you want to call her. The homewrecker, I don't know. At any time within, okay. So in an action brought to obtain a divorce on the ground of adultery, the plaintiff or defendant may serve a copy of his pleading on a co-respondent named therein. At any time within 20 days after such service, the co-respondent may appear to defend such action so far as the issues affect him. Like, no, I didn't do it. Okay. So you can bring a co-respondent in, and anytime within 20 days after such service, after serving the girlfriend or whatever, they can come into court and defend themselves as to themselves. Okay. If no such service be made, then at any time before the entry of a judgment, a co-respondent named in any of the pleadings may make a written demand on any party for a copy of the summons and a pleading served by such party, which must be served within 10 days thereafter. So, if the person is that may serve a copy of its pleading, okay, so you serve a copy of a pleading, you have 20 days. If no such service is made, and I don't know how the respondent would find out, but if they find out that they're named in this pleading, they can write something in, and they have 10 days to get a copy of the summons and the pleading. And he may appear to defend such action so far as the issues affect him. 2. In an action for divorce where a co-respondent has appeared and defended, in case no one of the allegations of adultery controverted by such co-respondent shall be proven, such co-respondent shall be entitled to a bill of costs against the person naming him as such co-respondent, which bill of costs shall consist only of the sum now allowed by law as a trial fee and disbursements. Wow. Okay. All right. So again, adultery, if you serve them summons and pleadings, 20 days they have to defend the action. If there's no service, they can do a written demand for summons and pleadings before the entry of judgment, and that's 10 days. Okay. They may appear to defend themselves in both things, and they're also entitled to cost for a bill of costs against the person naming them as a co-respondent. Okay. 173, jury trial. There's a right to a jury trial of the issues of the grounds for granting the divorce. I'm missing 174. Am I missing 170? Yeah, I am. All right. Well, I have 175. Legitimacy of children. 1. Where the action for divorce is brought by the wife, the legitimacy of any child of the parties born or begotten before the commencement of the action is not affected by the judgment dissolving the marriage. 2. Where the action for divorce is brought by the husband, the legitimacy of a child born or begotten before the commission of the offense charged is not affected by a judgment dissolving the marriage, but the legitimacy of any other child of the wife may be determined as one of the issues in the action. Okay, so let's say you think that your wife cheated on you and you're like, I'm not sure if this kid is mine. Wait, I don't know actually. Wait. Okay, so your wife had a child before? I don't know. Okay. In the absence of proof to the contrary, the legitimacy of all the children begotten before the commencement of the action must be presumed. So this is like in family court with Article 4, a legitimate child is if you were married, that the children are assumed to be legitimate. Okay. The age that a child may be, can get, the age of marriage that somebody can get married is now 17, was just changed last year, March of 2017, where it used to be 14. Now you have to be 17. It is with judiciary and parental consent still, but that's not on our test, so just, it's a new law. So might be on the test with other raise the age stuff.